realities. He'll be discussing mostly on the aspect of doping. What is doping? What are the regulatory frameworks involved in it? How does a sample collection happen? What are the testing protocols? How does a hearing happen in NADA and other courts? Who has the burden of proof? And issues like that. Over to you, sir. Thank you once again, everybody, for joining in. Thank you, Parth, sir. Over to you.
Thank you so much, Hanif. Thank you, Hanif, for this. I'm grateful to you, Ranjit, Niharika, for your kind and generous introduction. Your words are humbling to me. I'm very nervous to see Mr. Rajaraman here. He knows anti-doping laws more than all of us. Uh, it's always very inspiring to see such genuine passion for sports and sports law, which I see in Offside Legal and your team. Thank you for having me on this webinar. Wishing all of you a very, both of all of you success in taking this platform to greater heights.
Yes, sir. So the first question or the first aspect which I would like you to talk about is what exactly is doping and how does it happen? What are the kinds of it which are involved? To get a perspective, to give everybody a taste of what the session is going about. So just on that aspect.
So, Hanif, I'm sure as you all know, the professional athletes who who take part in competition organized by national sports federations and international federations are subject to anti-doping, which means that the anti-doping agencies may collect their samples in competition and sometimes out of competition. And the anti-doping rules are framed by World Anti-Doping Agency, WADA, and they have framed laws, rules which govern the anti-doping regime all over the world. Being signatories of International Olympic Committee, all the international federations and their affiliate members, which are national sports federations, are bound by the anti-doping rules framed by WADA. So in India also, we have to follow the same rules which WADA have framed, which is universally applicable to all anti-doping agencies in the world. So the athletes' samples, mainly urine sample and sometimes blood sample also, may be collected by the anti-doping agencies. They are analyzed in WADA accredited laboratories and they are checked for using any prohibited substance. So the WADA prescribes a list of prohibited substance and methods which are banned in competition, out of competition in sports. So when the analysis happen in the laboratory which is accredited to WADA, they specifically check for presence of those substances, their metabolites, their markers. And in case any athlete is found positive, or the term uses there is an adverse analytical finding, they are subject to sanctions as per the rules. The rules enforce at the moment are WADA anti-doping rules 2021. And as per those rules, the sanction may go up to 4 years for first offense for non-specified substance. And then there are specified substances which are stimulants for which the sanction could go up to 4 years if the anti-doping agency proves intention. So the regime is extremely strict. The rule of strict liability applies to the proceedings. So, rule of strict liability means that it is for the athlete to prove its innocence, not the other way around, which we see in Indian legal system, Indian criminal system, where there's a presumption of innocence and the burden of proof is on the uh, prosecution to prove beyond reasonable doubt that the crime has been committed. In the anti-doping laws, it's a rule of strict liability. So once your sample is tested, a three sample is tested, it is found positive for a prohibited substance, rule of strict liability applies, and it is for the athlete to show that he is innocent, he has no fault, no significant fault, or no intention of using that prohibited substance. So the burden is on the athlete to show his innocence. There are several anti-doping rule violations as far as anti-doping rules are concerned. First, definitely is presence of a prohibited substance and markers in a athlete's body. So if it is a prohibited substance is found present in your sample, it is the first and very basic anti-doping rule violation. Then the anti-doping rule violations which are prescribed in the rules are use or attempted use of a prohibited substance or marker, evading or refusing and failing to refuse, failing to submit the sample. So if a dope control officer approaches an athlete, informs him about his identity and wants to collect a sample, and if an athlete tries to evade, refuse, or fail to submit, that also is a anti-doping rule violation. Then there is a violation which is called whereabout failures. So the athletes who are part of registered testing pools. So there are certain athletes on which there is a special attention of the anti-doping agencies who are performing well at national and international levels. So they are placed in a registered testing pool, and they are required to inform their whereabouts, their place of training, their place of residence in a prescribed format to the anti-doping agencies on on a software called ADAMS. And if the anti-doping agency officials reach that particular place where the athlete trains and resides, as per the information provided by the athlete, and the athlete is not found at that place, it constitutes a whereabout failure. Then tampering or attempted tampering with the part of doping control by an athlete. There have been cases recently where there have been allegations of tampering with the process by the athletes. That also is a violation. Then possession of a prohibited substance or prohibited method by an athlete or athlete support. So even if you are in possession of um, a substance which is prohibited in sports, that could also constitute anti-doping rule violation. Trafficking or attempted trafficking, for having in possession of large quantity of a prohibited substance. Then administration or attempted administration by an athlete or other persons. This is also an anti-doping, that is Article 2.8, and Article 2.9 is complicity or attempted complicity, where a person is complicit in anti-doping rule violation with an athlete. So that is also a very recent case of Coach Ramesh Nagapuri, who has been charged with complicity when two athletes evaded dope control process. And these are mainly the anti-doping rule violations as per the anti-doping rules 2021 of NADA.
So when you talked about strict liability, how adversely it impacts a athlete? Uh, is it one that destroys one's career, or is there a possibility that he or she can be like you said, that there is a presumption of innocence in the law we talk about? Is there any presumption of innocence here that we have seen in the case of Prithvi Shaw, that when it was a case of innocence, that he did not know that what he is consuming, he was ill and he consumed cough syrup, and that had a prohibited substance. So how strict NADA and how strict the laws are?
So Hanif, let me put it this way. There's no presumption of innocence. Like I said initially, that there is a rule of strict liability. However, there is a provision which specifies what is the burden of proof on NADA in such cases, and what is the burden of proof on an athlete. The Article 3.1 of the rules say, I'll simplify it. that for NADA, for any anti-doping agency to prove any case and establish any case against the athlete or athlete support, they have to prove the case uh, to a comfortable satisfaction of the panel. Comfortable satisfaction of the panel would mean a case which is a bit lower in pedestrian to beyond reasonable doubt, but above what we say balance of probabilities. So the burden of proof on the anti-doping agency is comfortable satisfaction of the panel. So I'll try to explain how this works. So in a case of presence of a prohibited substance in the athlete's body, the burden of the anti-doping agency is to prove that the sample was collected in a proper manner as in terms of the international standards of testing in laboratory. All the processes were followed, and thereafter the testing was done in a WADA accredited lab, and there is an adverse analytical finding. There is no deviation whatsoever from the international standards. So therefore, in such cases, the anti-doping agencies, by establishing these procedures, establish by a comfortable satisfaction of panel that an anti-doping rule violation has taken place. When it comes to an athlete, the burden of an athlete to prove his innocence is prescribed as to prove the innocence in on a balance of probabilities. So whatever the defense an athlete raises, he has to prove it on a balance of probability. The athlete does not have to prove the case beyond reasonable doubt. So balance of probabilities means 51% likelihood of an event happening as opposed to 49%. So that is balance of probabilities, which a lot of court of arbitration of sports jurisprudence has laid down. So athlete has to show that his defense is plausible, and 51% chances of such defense having been occurred. So there is a perception that an athlete has to establish his case beyond reasonable doubt, has to bring in a case which is foolproof. But as far as anti-doping rules are concerned, it is only on the balance of probabilities that an athlete has to establish his defense, whether he has consumed it intentionally or not intentionally, unintentionally, whether he had no fault or no significant fault or no significant negligence in consuming or the prohibited substance. The athlete only has a burden to prove it on a balance of probabilities. So therefore, of course, there are instances where anti-doping rules, where a prohibited substance is found in the sample of an athlete. So there is no need to panic for an athlete. As a uh, lawyer, as a anti-doping lawyer, worked for 16 years, I try to speak to the athlete and gauge what is their defense, how the prohibited substance has entered their system, which is I would say extremely important, because if you have to prove your innocence, you'll have to establish the source how a prohibited substance has entered your body. So therefore, as far as anti-doping rules are concerned, Article 2.1 is extremely clear. Athlete is responsible for what he ingests. So there cannot be a defense where an athlete comes and says that I do not know how this has happened. So therefore, it is the complete responsibility of athlete to see what he consumes, what he ingests. And when an anti-doping rule violation occurs, he has to come out by establishing how the substance has entered the system. So this is how the burden of proof rule works in the anti-doping rules.
So also, there is a clause I know that TUE, which talks about therapeutic use exemption. So if you can also shed some light on how does it work, what application an athlete needs to file, And are there any strict liability on that as well, or how does it work?
So therapeutic use exemption is an exemption granted to an athlete under the rules where an athlete is allowed to consume a substance which is otherwise prohibited by the World Anti-Doping Agency. However, that substance is required by the athlete for a medical treatment. So if an athlete wants to undergo a treatment and obviously has to inform his treating doctor that he's an athlete and he may be subjected to anti-doping testing, and the treatment involves a substance which is otherwise prohibited in sports, an athlete may file a therapeutic use exemption application before the anti-doping agency where he has to bring forward under what circumstances he requires such prohibited substance. So he'll have to place on record the entire diagnosis, the doctor's opinion before the anti-doping agency, and anti-doping agency usually has a panel of doctors who decide the therapeutic use exemption applications of the athlete. There are certain parameters under the rules where which have to be considered by the panel before allowing or rejecting any therapeutic use exemption, which primarily involves whether the athlete genuinely and actually need the prohibited substance, whether there is an alternate treatment available where an athlete could use any other medicine or substance which is not prohibited. So these are the factors which the panels usually consider while granting or rejecting a therapeutic use. So if a therapeutic use exemption is granted to an athlete and he uses a prohibited substance, and when he's tested, if that prohibited substance is found in his sample, he has a defense of a therapeutic use exemption and there will be no anti-doping rule violation.
Sir, you also talked about the case of Ramesh Nagapuri. If you can also shed some light on that case, what were the facts involved and what were the finding of the NADA?
So, Anif, since this case is already sub judice under before the discipline panel, I would not be able to go into details. However, whatever is reported and already in public domain, I can shed some light on that. That the case involves evasion and refusing to submit sample by two athletes when the anti-doping agency went to a particular stadium. The two athletes, one of them evaded, other refused to sign the dope control forms, and therefore they ran away and they did not submit to the anti-doping process. The case before the panel against the coach is that he was complicit, and there was an alleged uh, involvement of the coach in the evasion by the two athletes. So this is one of the rare cases which I've come across uh, in my anti-doping career. That's of complicity. So there's an allegation that the coach was involved when the athletes evaded the dope testing.
So moving on to the other facet. So when a normal case comes to you, how do you adjudge that how do you want to go forward when an athlete comes to you? What do you tell the athlete, and also how does the filing process and hearing process in NADA happen?
So when there's an anti-doping rule violation, the first notice which athletes gets from the agency after his sample is collected is the notice of adverse analytical finding, which informs the athlete about the violation, whether there is any presence of any prohibited substance in his sample which has been collected. Obviously, there are other violations also for which there would not be a notice of adverse analytical finding, but there would be another other notice of violation. But this is the first notice which usually an athlete gets about the presence of a prohibited substance in his body. The athlete thereafter is given opportunity for B sample testing, for obtaining lab documents, and these are all time-bound processes under the anti-doping rules. Then if a athlete wishes, he can go for a B sample analysis if he's sure that this could not have happened. And then the process moves on to the notice of charge from the anti-doping agency, where athlete has to then explain his defense before the anti-doping agency. Thereafter, the matter is placed before the anti-doping disciplinary committee, which is the first instance adjudicating body. And thereafter, there is an appeal committee also, which deals with the appeals which comes from the decisions of the anti-doping disciplinary body. And thereafter, an athlete has an option of approaching court of arbitration of CAS also. But in between these processes, the athlete is also given an option to accept the consequences. So if an athlete uh, is accepts those consequences, he has to waive off his right to hearing, and uh, may accept a 3-year sanction by waiving off his right to hearing and accepting the consequences. So that opportunity is also given to an athlete, which I feel reduces the burden on the anti-doping panels also. And an athlete who wants to accept the consequences which are brought forward before him may do so.
So, have you come across any case where the athlete has accepted it?
Yes, yes, Hanif. In fact, ever since 2022, 2021, rules came into force, there have been multiple cases, many cases where athletes have accepted consequences, and this happens when athletes know that they have no defense. So they have probably done it uh, intentionally or under influence or under by being misguided by somebody, and they have no defense under the anti-doping rules. So athletes many a times accept the consequences, which actually has reduced burden on the panels to adjudicate cases and write orders. So this the entire process is completed in a very short time frame, which usually is 21 days after the issuance of notice of charge. So athlete is granted 21 days to accept consequences. So the time limit of 21 days is a strict time limit, and the delay this cannot be condoned under the rules. So if 21 days period is over, the athlete thereafter cannot come and accept consequences and get his sanction reduced.
So, you also mentioned that the athletes, need to prove source of prohibited substance to get sanction reduced. Can athlete get reduction without proving the source?
Uh, yes, there have been cases where reduction have been given to athletes without proving the source. Uh, there is a provision in the anti-doping rules, Article 10, where which says that an athlete, if it proves that the anti-doping rule violation was not intentional, can get the sanction reduced from 4 years to 2 years. And if we dive deep down the provision, it nowhere specifies that for proving that the anti-doping rule violation was not intentional, the athlete has to prove the source of the substance. However, if the athlete takes the route of a defense of no fault or no significant fault, the definition of no fault and no significant fault provides specifically that the athlete, to prove no fault or no significant fault, has to prove the source of the substance, how the substance entered his body. However, there is a slight difference in the language where the athlete, if he wants to prove that the ingestion was unintentional, he may not have to prove the source of the substance. So these uh, but this is an extremely difficult set of cases because if you do not prove the source, it becomes difficult for the panel to determine whether it was intentional or unintentional. But there have been several cases in India as well as internationally before the Court of Arbitration and other anti-doping agencies where athletes' sanction has been reduced where without even proving source. There are multiple other factors which are considered by the panel, and um, looking at the case under the totality of circumstances, the panel may go ahead and reduce the sanction after determining that the rule violation was unintentional.
Right, sir. So also there are two questions in the chat box if you would like to take. One is that what kind of punishment can be awarded apart from suspension?
So, apart from suspension and sanction or from prohibiting an athlete from participating in any competition, sporting competition, the rules also provide for taking away medals, awards, prize money awarded to the athlete. And sometimes, if the rules can also prohibit an athlete from even training at sports complexes, even taking up coaching, and returning of prize money and medals, like I said, were also part of the sanctions under the rules.
Right. And the second question is that are the competition results also discarded if the adverse sample was collected in the competition?
Yes, these are the natural consequences of anti-doping rule violation. So, if your sample is collected in a competition where you have achieved a certain result, and thereafter the sample comes out positive and there's an anti-doping rule violation, the results achieved by the athlete in that particular competition also are taken away.
So, sir, is that a provisional suspension or it's a full-time 4-year ban on the athlete?
No, so there are two kinds of cases where one is a case of non-specified substances, which are the cases relating to anabolic steroids, uh, and selective androgen modulators. Those are cases of non-specified substances where when the analysis of a sample is done and it is found positive, the athlete is automatically placed under provisional suspension from the date of the first notice of adverse analytical finding. Then, in contrast, there are cases of specified substances, which are usually stimulants, beta blockers, which have a tendency of getting into system of a person inadvertently also through routine medications like cough syrups. So those substances are specified substances. So when a sample is found positive for a specified substance, the athlete is not automatically placed under provisional suspension. There is an optional provisional suspension given to an athlete. So if an athlete feels that his defense is somewhat which may eventually give him some sanction, so the athletes have an opportunity to accept the provisional suspension from the date of notice of adverse analytical finding, so that till the time the eventual hearing process is complete, that period of provisional suspension also is counted in his favor in the eventual sanction. So this is the difference between a provisional suspension for specified and non-specified substances.
So during the provisional suspension also, are you permitted to play or you're not?
No, athletes are completely barred from participating in any competition during the provisional suspension. And if an athlete during the provisional suspension or after the eventual sanction by anti-doping panel participates in any competition which is conducted by a national federation or international federation, there is further sanction to such an athlete, and which may have, lead to a suspension of another 4 years, depending upon the facts of the case.
Right, sir. But then also we see that later, after adjudicating the case, the person is found to be innocent. Now, in those cases, he loses those crucial months. And we all know that for an athlete, the time frame is very important. So we need quick actions and adjudications for that. How does that impact the athlete mentally also and physically also?
So, you're absolutely right, and therefore the anti-doping rules also provide adjudicating of a case within a period of 3 months, which unfortunately does not always happen. And you are right. If an athlete fights a case for over a year and is eventually exonerated, there is no ban. He, in any event, loses that crucial 1 year period. So therefore,
Right.
there is a provision in the rules which provides that the 3 month period that NADA has, the anti-doping agency has to adjudicate a matter. But this is not happening. I mean, as far as it is concerned, practically it is concerned. It is a problem area for sure, and definitely we need anti-doping agencies to uh, adjudicate these matters in a time-bound manner and within the prescribed time frame provided under the rules. Otherwise, it is definitely uh, issue for an athlete who is an innocent athlete and who eventually proves his case before the panels.
Right. And then also, sir, because I would say this is one of the biggest challenges in India, that there is lack of awareness. Like for an athlete who is coming from a district level or from a village, he wouldn't know about all these rules and regulations. He would be focusing more on his athleticism and not on these issues. So, what is the role of awareness of doping, and how do we bring those athletes in line with this thing?
So, see, making athletes aware about the prohibited substance, about the anti-doping rules, is the primary job of any anti-doping agency. And of course, it is the job of the National Sports Federation also, under which an athlete participates in these events. I'll tell you a story. So, you are right. When it comes to athletes who come from backgrounds where they are not educated. They come from humble rural backgrounds where there is no education to them. They are they just start competing, training, and start competing in the competitions. I came across a case a few years ago where this was a 15-year-old boy from a very small rural area of Uttar Pradesh, had hardly gone to school and had absolutely no idea about the anti-doping rule violations. He started participating at district level competitions, and because of his talent and hard work, was he was selected for the national inter-district championship because he won the district level competition. And when he went there, because he was doing really well, he was tested by anti-doping agency. His sample was collected, and his sample was found positive. When I interviewed this athlete for taking up his case, I came to know that he had absolutely no idea there was any anti-doping agency in place, that anything such as anti-doping rules existed also. So he was watching YouTube videos, Instagram videos, where uh, there were advertisements about products which could give you strength. So he, being not aware of anti-doping rules, the prohibited substances list, he just went ahead and purchased those substances. And unfortunately for him, those substances had prohibited substance in them, and he was found positive. So anti-doping, because he had no anti-doping rule knowledge, no knowledge of prohibited substances, he was eventually banned. Uh, so therefore, anti-doping agencies and federations have, of course, the uh, burden of educating the athlete. It's their primary job to educate athletes so that less anti-doping rule violations occur in a country. I'm sure anti-doping agency in India is doing this, but India being such a large country and athletes coming from different part of the country, it's a process. It will not be fair to say that anti-doping agency will be able to reach all the athletes in various districts of the country, but they of course are doing the job, and it will take time. It will take time.
Right. And sir, you mentioned that that kid was only 15 years of age. Right. And we also see in criminal cases that there is some sort of relaxation or exemption to minors. Is there any case where you have come across where a minor has been given a relaxation on this account?
Yes, so anti-doping rules 2021 has a definition for protected person. Protected persons are athletes who are below the age of 16 years and who have not played, 18 years, and who have not played any international competition. So the only relaxation given to them under the rules is that when there's an anti-doping rule violation, uh, and the relaxation given to them is that they may not even show how the prohibited substance has entered their body. So if you are a prohibited person who have not played an international competition, you are under the certain age, you are not. It's not required under the rules for that person to show how the prohibited substance entered the body, and still can get some benefit. So so if we go by the CAS jurisprudence, the it is very clear that the age, experience, the anti-doping rule awareness, knowledge about anti-doping rules are definitely factors which the panels have to consider before giving any sanction to any athlete. So one under the rules is the protected persons are not required to show how it entered the body. Number two, as far as jurisprudence is concerned, education, experience, age, everything are definitely the factors which panels have to consider.
Right, sir. Also, moving on to the last question, I would like to just know from you when we say that India has been topping the charts in anti-doping rule violations since last 3 years now. So, what according to you can be done in a better sort of way, or what is the way forward for India so that these anti-doping rule violations come down? How do we go forward, and how do we advise, or how do we spread awareness of the same?
This is a very important question, and especially for all of us, because the like you said, the numbers are rising, and India was number one in anti-doping rule violations. Number one, of course, is educating the athletes. As far uh, as many athletes as possible, anti-doping agencies, government, national federation, of course, have to reach as many athletes as possible, educate them, guide them that they cannot use any substance recklessly without reading the ingredients of that substance, whether any prohibited substance is present or not. There are cases where athletes do not know that they cannot even take certain medications because they are prohibited. So athletes who participate actively in sports competitions are required to be educated that they need to tell their doctors that we are athletes, and there could be an anti-doping sample collection, and therefore do not give us any medication which is prohibited in sports. That is also extremely important because we are seeing many cases where doctors have prescribed medications which are prohibited in sports. Then, in addition to that, according to me, the availability of the prohibited substance in the market is very easy. So, I mean, it is so unfortunate that even if you uh, open your apps and you Amazon and Flipkarts and others, you can order certain prohibited substances. So this has to be curbed for, according to me, because if it is so freely available, it can be abused. I mean, there's likelihood that it will reach the hands of the athletes and they'll consume it. These are the things which we need to keep in mind if we have to reduce the number of cases. And of course, there has to be deterrents, and there have to be strict punishments, which already are as per the rules. And people who are, see, the coaches and other people who are guiding these athletes to get into anti-doping or these using these substances must also be taken to task, according to me.
Right, sir. So one last thing, we also see cases in which the athletes, we see there is a lot of competition, right? And we see there is a lot of tampering also. That the coaches sometimes favor one athlete more than the other, and because of the competition, the other athlete tampers the person's food or some drink or something. And we have seen those cases also. So, how big a role does a coach and other athletes play in this?
So, see, yeah, there have been allegations. We've all read several reports about athletes alleging that a competitor or the other athlete has tried to spike their food or drink with a prohibited substance, and so the see, actually, like I said initially, the rules always provide that it is the athlete, first of all, who has to be vigilant and who is responsible for whatever he ingests, whatever he eats. Proving a case where there is an allegation that somebody might have spiked or food or drink is extremely difficult unless there is a clear or direct evidence of other person doing it. So it is, I always tell my athletes to be extremely vigilant, especially athletes who have reached a certain level. They have to be extremely vigilant of what they eat, what they drink, where they keep their stuff, or like their supplements or their water bottles or their food. So it is according to me totally up to those athletes to be extremely careful in not eating or drinking something which they have a doubt on and which have not been in their own possession.
Right, sir. So we have some questions which we received while the registration was on. We'll take up those questions.
Yes, please, please.
So the first question is from Mr. Swastik Patnaik. He says India consistently ranks amongst the countries with highest ADRVs per year. Why do we not see enough appeals to CAS? It is lack of resources at athletes and lack of quality legal representation. The sporting career not being lucrative enough to fight for. What is it?
It's a combination of all. It's a very good question. One is, according to me, lack of resources with the athletes also to reach court of arbitration. It of course requires expenses. The BADA rules, Code of Arbitration rules, provide that athletes can get legal aid also there. That is also a possibility. However, there are two panels here, two levels of panels here in the National Anti-Doping Agency, which is disciplinary panel and then appeals panel. Most of the cases which I have seen in my experience do get adjudicated at that level. There's a disciplinary panel, then there is an appeal. And even if an athlete is not satisfied with the uh, sanction or determination of case by any of these panels, they can of course reach CAS. But like I said, resources with the Indian athletes are, according to me, limited, and very few cases, like Swastik has pointed out, has have reached CAS. There have been, of course, cases which have reached CAS, but the numbers are very few. So, however, then there are very rare cases where I feel an athlete has felt that there was not a fair decision and he needs to go to a CAS. There is definitely an option. There is a legal aid provided there as well. Athletes can definitely approach CAS if they're not satisfied with the decisions.
Right, sir. The second
And
one
then
is
one more
from.
thing which I want to add in Swastik case is the the level of evidence an athlete has, which may lead to eventual reduction of a sanction. The athletes always evaluate that also, that they have exhausted their two remedies before disciplinary panel and their appeal panel, and they've not been able to satisfy these panels on the basis of evidence which they have in their possession. So sometimes there is a concern that they may not even be able to satisfy code of arbitration of sports with the evidence available with them. So that is also one of the factors people do not sometimes approach court of arbitration.
Right, sir. The second one is from Miss Purva Patel. She says, "What are the biggest challenges in detecting?" Sir, can you? Hello.
Yes, Hanif.
So there is some disturbance. One second. So can you mute yourself, please, sir? Doctor MD. We'll move forward. She says, "What are the biggest challenges in detecting modern doping methods, and is the law keeping pace with these advancements?"
Yes, according to me, definitely World Anti-Doping Agency is keeping in pace with modern doping methods, and we see every year different kinds of detection methods are devised by the World Anti-Doping Agencies and several international sports federations to keep up with the doping methods. And according to me, enough research is going on everywhere in the world because doping in sport is not tolerated at all. The sport has to be extremely clean and fair. And therefore, the World Anti-Doping Agencies, international federations are keeping track of how athletes dope, and they are taking care of all these uh, violations and methods of the athletes use for doping.
Right, sir. Moving on from Dr. Himanshu Vishwakarma. He says, "Sir, as a sports physiotherapist, can I become a doping control officer or any other position I can go to?"
So, Anif, will not be able to answer this because it is for the national anti-doping agencies and international doping agencies to appoint dope control officers, and I'm sure they have their requirements and the qualifications are prescribed there. So, I may not be able to answer that.
Right, sir. No problem. The next one is from Jaya Aditya Vyas. It says, how are specific footballers chosen in matches to undergo doping test? Example is of Paul Pogba's random testing during his tenure at Manchester United.
So, yes, this is an interesting question because sometimes in team events, it's not the entire team which is tested, and the samples of the athletes are collected randomly. I do not know what methods they use to identify which athletes have to be tested, but of course they monitor the performances of the athletes over a period of time, and they have their data, and which according to which plan is given to the dope control officers to check the athletes in the team events. There of course could be random testing also. I've come across cases where randomly players of a team have been selected for doping control process. So it is again for the anti-doping agency to tell us how they randomly select players in a team game. But of course, according to me, it has to be based on some parameters. Their performances are checked over the period of time. There is a check and balance, and therefore they pick up players of a team.
That's it. We'll open it all for the audience if they have any question. I think Nitya has raised his hand. Can you unmute yourself and ask your question, please?
Yes, sir. Hope you're doing well, sir. So my question is basically around women athletes and female athletes in specific. So, there have been studies where which say that female athletes have various hormonal imbalances during certain time during when they are uh, participating in an event or in any other situation. So this may also lead to an increase of estrogen levels in their bodies. So does this also, how in such a scenario, if an in competition testing has happened and the test has come out for maybe an elevated level of a certain hormone in their body, which falls under the prohibited list, or in such a scenario, then what would the defense be for the female athletes, sir?
So Nitya, I must tell you that when the sample is analyzed and there is the sample is analyzed in a WADA accredited lab, and such an so the result also clarifies whether the testosterone levels have increased due to an exogenous product thing which has entered their body, which has been brought into the body system from outside, or whether it has naturally occurred. So the testing agencies are well equipped with the methods which would clarify whether uh, something from outside has been brought into the system, which has led to increase in these levels. So the reports of the labs, when we read it carefully, also clarifies whether it has come naturally, with the levels have increased naturally, or anything from the outside has been uh, taken by an athlete, which has caused the levels to increase.
Understood, sir. I have one more follow up, if there's time for it. So there for increase of testosterone for endogenous reasons. So what I have read upon says that if a cancer tumor or a cancerous tumor is present in an athlete's body, it may increase the testosterone level. Now, that might be an unfortunate situation for the athlete, but ultimately, an increased level of testosterone would somewhere result in a performance enhancement, which is exactly the aim that anti-doping tries to prevent. So, in that situation, even though it may be an endogenous reason for increase of testosterone, wouldn't that be unfair for the other athletes?
Nitya, I would say that such a situation, the levels of testosterone level which are acceptable, I don't think that it may go beyond that, because the accepted levels are also based on certain researches and studies done by the experts over the long period of time. So if such thing has occurred, I mean, I'm not aware, but there would be there could be a situation where these this could have happened, but I've not come across. According to me, the levels which accepted levels which are prescribed by the World Anti-Doping agencies are prescribed after careful and long research, and they do to their reasons behind that. So I may not be able to answer that technically. That would be for a medical expert to answer maybe some point.
Understood, sir. Thank you.
So we have one more raised hand. If you can unmute yourself and ask, please.
Good
Jay Aditya.
afternoon, sir. My question pertains to the appeal process. So I wanted to know when a particular athlete chooses to appeal, does it appeal go through the NADA or does it go through the Indian judiciary system?
So as far as the anti-doping rules are concerned, the rules also prescribe for an appeal in cases where an athlete is not satisfied with the decision of a first instance panel. If there is an international athlete, the athlete may directly approach Court of Arbitration of Sports. And there is a second level of adjudication, which is an appeal panel under the rules, where an athlete can approach. As far as judicial system is concerned, in India, if I may say that they have absolutely no role in adjudicating anti-doping rule violations and the sanctions. However, there have been cases which we have come across where a writ petition is filed by an athlete where uh, for a justifiable reason when the in the cases where say for example documents are not provided by the anti-doping agencies, which is a right to fair trial of an athlete. There is cross-examination or examination of witnesses have been denied by anti-doping panel. Again, in such a case, it is a fundamental right of an athlete for a fair hearing, and therefore for examining and cross-examining witnesses. If such instances occur, the Indian judiciary has stepped in their powers under red jurisdiction and have given reliefs to the athletes. However, the judicial system will not decide the sanction which an athlete would get in an anti-doping rule violation. That is not under their jurisdiction.
So we have one more question in the chat box. It says that in a team game, is any of the if any of the athlete fails to give doping test or proof, so that the whole team has to suffer, or that particular athlete will only suffer the consequences.
Say for example, in a team game like a relay race in athletics, if one of the athletes is tested positive, as far as I know, the entire team loses the medal. In cases of team games like football and hockey, I'm not so sure right now. I'll have to do my research also. But as far as athletics is concerned, when there are relay races, one of the athletes is tested positive. Of course, the team also loses the medal and the results. But it's a good
Right, sir.
question, which gave me food for thought. I'll deal with this also.
Yes, sir. Because
And
obviously,
also, we have Mr. Raja Raman here who can answer this question better than me.
so please, sir, if you can, Rajaraman sir.
No, I've known instances of teams being scrapped, a hockey team or a football team, having to pay a penalty if there is a player who has tested positive from within that. But in cricket, I have not seen this happen. Match result has not been overturned. The player has probably I haven't seen a positive test in competition. So most of the tests in cricket have come in out of competition testing. So we haven't seen a result being overturned in cricket, but I've known instances in football and hockey where teams have been scrapped for one person testing positive, just like in a relay race. But it is the person who's banned for 4 years. It's not the team that faces the ban.
Correct, sir. Thank you.
Right.
Thank you so much, sir.
Do we have any other questions? Anybody in the participants? If not, then we'll. Okay, we have one last one.
Hanif, actually, it's
Okay,
not a question.
that's a response. Right, right. Okay. So we'll be moving on to the closing statements, and for that, Ranjit is there. Thank you, Parth sir, for such a enriching and engaging session, and thank you, everybody. Over to Ranjit.
Thank you, Hanif. Thank you so much, sir. So we sincerely thank you too for delivering such a thoughtful and enriching session on doping in sports. So your insights, practical perspective, and the passion for sports law made the discussion truly valuable for everyone present. We are deeply grateful for your time and guidance, sir. It continues to inspire and shape our journey in the field. Thank you so much again, sir.
Thank you so much, Ranjit and Hanif, for having me here. Thank you.
Thank you so much, sir.
Thank you so much, everybody. Thank you.